Today, I'm here with Sarah Murillo from Murillo Law Firm, and we are just going to have just a little Q&A. I met Sarah at our BNI Goodyear Legacy, which we absolutely love. Yep, plug in for BNI. And I'm Rhonda Carstensen, and I am a commercial realtor. And just some of the things that I have learned from Sarah through our BNI classes or our meetings is just how extremely important it is to have a trust in place. Some of the stories that you have shared with us has just been cringeworthy, especially I have kids, grandkids. So tell me a little bit about what you do. Because people hear trust and it's just like, boring, right? And it's just
Correct.
like, I've never one time, I'm just like, wait for your new stories to tell us each week. So it's just like, tell us a little bit about what you do and how you can help people.
Sure. So I'm an estate planning attorney, and so I help people really avoid court and avoid family conflict. So with estate planning, if most people don't realize what happens when someone passes away and what probate is. And so what happens is if you pass away and you do not have a plan for your family, your house, your assets, everything could end up in the probate court. And what probate is the process that Arizona goes through to determine who the rightful owner of all your property is. So if you want to be able to tell the state who you want your property to go to without the state telling you, then you need some type of estate plan. And there's different types of estate plans that you can have. So you can do will-based plans and you can do trust-based plans. So a will-based plan, a lot of people don't know that a will actually is designed to go through probate. And so a will only does three things for you. So it allows you to name guardians for your minor child. It allows you to tell the state who you want your assets to go to instead of the state telling you. And then it also allows you to tell the state who you want to administer your estate when you pass away. But probate, again, is designed to determine, did you die with or without a valid will? So if you didn't die with a valid will, again, state statute will dictate how your property gets distributed. So this is a problem for people that might be single and in long-term relationships.
Okay.
So if you are in a long-term relationship, you pass away, your property is not going to your partner unless you have an estate plan designed, because state law would have it go to your parents if you're not married. And that may not be where you want your assets to go to. I had a friend who had a medical issue. She was estranged from her parents, but she was with her boyfriend for over 20 plus years. And when she was in the medical emergency, she didn't have a healthcare power of attorney, and her boyfriend ended up not being able to make any decisions for her. Her parents ended up coming in and making decisions that the boyfriend knew were not what his girlfriend would have wanted.
And was that because of the will or the medical power of attorney?
That's actually because she didn't have a healthcare power of attorney.
Healthcare power of attorney.
So,
Okay.
so estate planning is much more than just planning for death. It's planning for
Okay.
life as well. So planning for your incapacity. So with all the medical advances in today's world, you can live very long. We have lots of people living in their 90s and doing perfectly fine health-wise. So we want to make sure that if they ever do become incapacitated, meaning that they can't make their own medical decisions or their own financial decisions, that they've pre-nominated somebody to make those decisions for them so they don't end up in probate court.
What does it take to get a healthcare power of attorney? Because the sad thing is, I feel like every time I'm on social media, you turn on the TV, there's always an accident. Let's talk about the accidents on the Phoenix, Arizona freeways. Like, and so many of them are deaths or they are incapacitated. So what does that look like for somebody to say, look, this is what I want to have happen if something were to happen to me, and who I want that to take care of? And what does that, I know it's every situation's different, but what would that look like cost wise? What do they have to do?
So in Arizona, they actually have some free documents
Oh, okay.
available on the Maricopa County Superior Court website and on the Attorney General's office. So you can go in there and create your own healthcare power of attorney. But there are multiple documents that are included with healthcare directives. So it would be, you would want to do a healthcare and a mental healthcare power of attorney. You would
Okay.
want to do a living will, and then you would want to do a HIPAA authorization. So the healthcare and mental health care power of attorney allow you to nominate someone to make medical decisions for you or mental health care decisions for you. The reason that you would want that mental health care power of attorney is that's going to help someone that might have dementia or someone that might have suicidal ideation or some sort
Oh,
of
okay.
psychotic break that they may need some sort of psychiatric treatment or some type of stabilization. Um, and then the medical power of attorney allows the person that you nominate to make all the different types of healthcare decisions on your behalf. So they can hire and fire medical personnel. They can get you into hospice. They can get you into assisted living, anything medical related. There is the living will, and that's where people can make end of life decisions ahead of time so that their family's not guessing on what they would want.
Okay.
So if they have a doctor who has indicated that they are in a persistent vegetative state, meaning that they're not going to regain brain activity, they can indicate their wishes ahead of time and indicate whether they want to stay on life support and artificial nutrition, or if they're in that situation, they would want to basically pull the plug. They would want to make sure that they didn't stay in a vegetative state forever. And so instead of leaving your family guessing and trying to figure out what you would want in that situation, you can make that decision ahead of time so they know exactly what you want in that
Okay.
situation. And then the last document is the HIPAA authorization. So you go to the doctor, they cannot release your medical information, it's confidential without your permission. And so even if you have a healthcare power of attorney, it's usually embedded in there, but a lot of times the doctors want a separate document that authorizes them to release your confidential medical information. And so you do a HIPAA authorization that you name who you would want to make decisions for, or who you would want to have access to your medical information. A lot of times so that those people that you've nominated have the ability to get your medical information to make those decisions. But you can also nominate other people. So maybe your parents are older and you don't want to name them as your healthcare power of attorney. You want to name maybe your kids because they're younger and they're going to be around
And can you
longer.
name both
And
kids?
you can name, yes, so you can
Okay.
name. So I do not traditionally recommend doing healthcare agents.
Okay.
The reason for that, the whole purpose of having a medical power of attorney is to make sure that you have one decision maker. So if there
Okay.
is a disagreement, maybe you only have two kids,
I know my
and
kids would
and
disagree.
your two kids disagree, or you have a parent and a spouse that are disagreeing with medical care, that's where people end up in court because they can't come to a
Oh,
consensus,
okay.
they can't come to an agreement. So the reason you do a healthcare power of attorney is to nominate one person ahead of time that will be the decision maker instead of having a judge be the decision maker that doesn't know your family circumstances, that doesn't know you, and they are making the decision based on very limited information. So you want to nominate somebody, and normally I recommend one person. But if you would like, you can nominate two people, but you may end up in that same situation where
Okay.
they may
You have to go to
they may
court.
disagree.
Okay.
So
And
and
does that have to be filed somewhere for somebody to know that that's out there somewhere?
you do not have to file it, but Arizona actually has an Arizona healthcare registry. And
Oh,
so
okay.
for all of my clients, I will register them for free. And so then if there is an emergency situation, they're in a car accident, first first responders have the ability to pull that information up and they'll know who next of kin are. They'll know who to
Oh,
call.
okay.
They'll know what their directives are. They'll know exactly what they want for their health care. And so it's very important, I think, to get their information registered so that that information is available to
Okay.
loved ones. But anytime that you do create a healthcare power of attorney, you want to make sure that you've given a copy to those that you've nominated so that one, they know your wishes. And then if they have any questions, they have the ability to ask you while you're still alive and have your capacity.
Okay.
But you want to make sure everybody has a copy of those healthcare directives so that in the event of an emergency, they already have the document and they can go ahead and utilize it immediately.
Okay. Now, I want to go back to the will because something kind of sparked my little sensors. that a will does not eliminate you going through probate?
Correct. So a will, it does indicate who all of your assets go to,
Okay.
but a will is designed to go through probate. So the probate system determines whether you died with or without a valid will. If you died without a valid will, it goes away and the state statute dictates how your property gets distributed. If you died with a valid will and the judicial system accepts it, then your will control how your assets get distributed. But really, it's just the distribution of your assets. But for a will to take effect, you have to go through court.
So how do you go around, how do you avoid probate?
So one is to do non-probate asset transfers. So in Arizona, we actually have a way for your house to transfer outside of the probate system. It's called a beneficiary deed.
Okay.
So similar to beneficiary designations that you can put on bank accounts, you can put a beneficiary designation on your house so that it has a place to pass. So a couple of things that are important when someone passes away, the first thing that you look at is, are there beneficiary designations? Second thing you look at is, how was the property titled? Those two things control regardless of what your will or your trust says. So if you have a beneficiary designation and your will says something different, your beneficiary designation will control.
Okay.
If your property is titled different than what you have indicated in your will, so let's say you want to give your house to a niece, but you hold property as joint tenants with right of survivorship with your sister. When you pass away, sister automatically gets that house. It doesn't matter that your will says it goes to the niece.
Okay.
Because you hold title as joint tenants with right of survivorship. That right of survivorship takes precedence over whatever you had in that will.
So for example, so my house, I have it in my trust. I don't have a beneficiary deed to it, but in my trust, it would go to my son. And I put it that way because my daughter lives in another state, and it's like he wants that house. And so it's like, it's going to go just to him, to only to him. Am I safe with how I have it set up, or do I need to do a few additional steps?
No. So you have correctly what we call funded your trust.
Okay.
So trust is another way to avoid probate. So trust is very similar to a will, where you can indicate who you want to administer your estate. So in a will, it would be called a personal representative. In your trust, it's called your successor trustees. And you also indicate in your trust who you want all of your assets to go to. And so documents alone do not create an estate plan. So if you only have that trust document, it doesn't do anything. So the way that a trust works, it's kind of like a treasure chest. If you have nothing in that treasure chest, it's worthless to you. Same thing with a trust document. If you have nothing titled into the name of the trust, it's a worthless document. So a lot of people are walking around with trust documents and they think that they are protected, and they are not, because again, the document alone doesn't do anything for you. The way that the trust works is you are retitling everything into the name of the trust so that when you pass away, you own nothing in your name, so that nothing goes through probate.
Okay.
So for your house, you retitled it from your individual name into the name of the trust. So now the trust will dictate how that asset passes. And so if in your trust you have indicated that it goes to your son, that's where that property is going to pass. So one of the really nice things about a trust is you're just titling it into the name of the trust, but your trust can indicate all sorts of things as far as how that property can be distributed. So you can put multiple beneficiaries. So let's say something happened to your son, you can indicate now it goes to my grandchildren. Something happened to my grandchildren, now I want it to go to a charity. Something happened to that charity, now I want it to go to somewhere else. So you can do multiple layers of what would happen to that piece of property so that there's always a place for it to go. You want to make sure that when you pass away, every single asset that you own has a place to go. So one of the things that I do that is unique is before I even meet with my client for the initial meeting, I'll have them do homework. And part of that homework is identifying everything that they own. Because again, those documents alone don't do anything. We need to have a plan for every single asset that you own. So we'll do an asset inventory that then we can create I'll have an inventory that they can provide to their loved ones. The loved ones know exactly what to own. The biggest thing
Okay.
that happens when someone passes away, trying to figure out what they own, because my kids would have no clue that I have life insurance with this company, or that I own a second piece of property over here. They don't know what I own. They don't know where my investment accounts are. And so being able to have that ready for the kids. So I collect, account numbers, what type of accounts, how is the title held for that? What beneficiary designations do we have on those assets? And then we create a plan for every single asset to make sure it aligns with what they really want for their estate plan. And so having that asset inventory is so important, because if you don't know what your loved ones own, or if you can't even figure, because a lot of times people are not financially organized, so they don't even know everything they own. So having that list, getting that documented, and then making that available for your loved ones is such a blessing, because then they know exactly what they need to collect. There's no hunting through all of your mail, hunting through your email, trying to figure out what you own. I had one client that they didn't know that their loved one had a life insurance policy. It was billed on an annual basis until almost a year later when they got a bill, because they didn't know. And so they had to do GoFundMe. They struggled trying to figure out how to pay house payments, how to pay for the burial. And then
a year later,
they find out that they've got a life insurance policy that would have saved so much stress and heartache for that family. And so, like I said, it's so important to have that. The other thing that happens is, if your loved ones don't know what you own, it ends up with the state's Department of Unclaimed Property. And so there's over $2 billion sitting there in Arizona.
Just in Arizona?
Yeah, unclaimed, because people don't know what their loved ones own. And they just don't find the documentation when they're searching the house, and so they just don't know.
So if somebody comes to you, what do they say? Something were to happen to me, who, like, my son reaches out to you, my daughter reaches out to you, how does that work? That people, like, you've gathered all this documentation, do you just say, this is your document, keep it in a safe place, and let your loved ones know that this is what you need to do if something were to happen to me? This is all my information.
Yeah. So a couple of things that I do with my clients is, one, they will get a binder, an estate planning binder, with all of the original documents. So they will house all their original documents. One of the things that we do not have here in Arizona, or I don't think in many of the states, is a way to track everybody that has a trust. There's no trust repository. And so the only
way...
Why
is that?
The state just hasn't developed one. And so nobody knows that you have a trust except for you. So there needs to be communication with your family.
It's the $2 billion, I'm just going to guess. Just kidding, but serious.
So nobody knows that you have a trust. And so if you have not told your family where those documents are, they may or may not know that you even have a trust. So for me, it's very important for families to have those conversations, and they're very difficult conversations for families to have, because you're talking about your own demise, your own death. But I try to help facilitate that. So one of the things that I do also that's a little unique is I will send out a fiduciary letter. So those people that you've nominated, I will send out an email to them and just let them know, hey, you've been entrusted with this responsibility after your loved one passes, so that they know that they have that responsibility, that can start that conversation with their loved one. But I also give them my contact information, so that if something happens, they have somebody that they can reach out to, that they can trust, and I would help walk the family through what are the next steps. And hopefully, part of my planning process is making sure that your trust is fully funded. So a lot of people are like, well, what is funding? I don't understand what that means. Again, that's the retitling of all of your assets into the name of the trust. Or if you're not able to retitle something, making sure that you have the correct beneficiary designations on all of your assets. My goal is, by the time we're done meeting, that my clients have their trust fully funded, that we know that their estate plan is going to work when their family needs them. Most attorneys, after they sign the documents, they tell the client, you need to do the funding, and the client leaves thinking, okay, they may not understand what the funding means. And so again, they're walking away with all these documents. It's a ton of information.
And then, funding, to me, it's just like, oh, I got to put money in some account. And it's just like completely the opposite of what it truly means.
Yes. So usually, there'll be some instructions that will go along with it, but people don't understand what that means. They don't understand the importance. And so they've signed the documents, they walk away, and usually they never talk to their attorney again. So two things that I do differently is one, I meet with all my clients every 3 years, because estate plan documents, and it's a free review just to make sure, do we need to make any changes? Have family dynamics change? The friend that you put in your estate plan, are you still friends? Have you gotten new assets? Have you lost some assets? And so my goal is to make sure that their plan stays up to date throughout their lifetime. So my goal is to be your attorney for life, and to make sure that you and your family have a trust person that they can come to if anything happens. The other thing is, after the signing, that is not when I disengage with my client. So at the signing, it kind of begins another relationship. So at the signing, we will walk through their asset inventory, and I'll walk through every single asset and walk my client through how to make sure that that asset is funded into their trust, or they have a correct beneficiary designation. My goal is, by the time that I have my final meeting with my client, from the signing to when I do the binder delivery, that they have their trust fully funded, so that we know, like I said, that it's going to work for their family when they need it. And so at the binder delivery meeting, one of the other things that I do is I do a legacy video with all of my loved ones. So I lost my mom when I was in my early 20s, and I wish, now that I'm older and wiser, that I had asked her questions. But you lose that opportunity when you lose a loved one.
Of
so
course.
you don't get to ask all those questions now that they're gone. You lose memories, you lose value, you just lose so much. And so instead of just transferring your financial wealth, I help families transfer their those intangible things, those things that you can't get back, those memories. Okay. And so I walk my family through a video where we ask about, about their lives, about their parents, their grandparents, what they did for a living, how they started the career. We talk about their childhood, where they grew up, their neighborhood. We talk about, if they're married, how they met their spouse, and we go all the way to, how children change their lives. And then what do they want to pass on? What values are important to them that they want to pass on to their children, make sure that they instill in them. And so that is also part of their estate plan, so that they're transferring not just their financial, but those intangible things that you can't get back.
That's got to be an emotional roller coaster going through that. But that's a priceless gift that you leave to your loved ones. Like I would give anything to just to be able to hear my mom's voice again also. Mm-hmm. That is just like, just okay, I just need to listen to my mom because I just am having a tough day. Mm-hmm. How awesome.
And I know a lot of people will hold on to a voicemail because that's all they have left of them, yep, is listening to that voice. Mm-hmm. But with the video, you get to see the mannerisms, you get to see your parents interact, or your loved one interact, and you get to hear their voice, and also see their body and see their face, and
especially some of their responses, because my mama was like me. It's just like spitfire. Oh, okay. I just needed to hear that today.
So. Yes, and the videos are very organic. They're not designed to be, professionally edited or anything. It's designed to just be the real person, just getting to know them and kind of like an interview with them.
Perfect. So one of the questions that as a commercial realtor, I have a lot of clients that some of them, they have businesses that they're owned with other people. So how does that work, and does that look like when, say something happens to one of them, and it's been a legacy that they've left, and there's like 10 people that kind of own this business, and the idea is it just keeps going down to these heirs. How do you address that, and how does that, it just seems so, I cannot wrap my head around it, that it's convoluted, that the business keeps going, but now there's new people coming in. And I'm sure that there's just so many people that have asked me that question, and I'm like, not my lane, got to go do this. But it's a question that comes up literally all the time in my business.
So that's a very complicated type of estate plan. But yes, you always, so I deal with a lot of small businesses, and you need to have a succession plan. What happens when you pass away? Where do you want your portion of the business to go? And so it's the same thing. If you have 10 partners all that have a plan, depends on how their operating agreement is, or their business agreement is, depending on what form of business they hold. But if they have an LLC, they should have an operating agreement. your operating agreement. So in Arizona, I will just tell you, most people that create LLCs, they just go to the Arizona Corporation Commission, create the articles of organization, create the LLC, and that's it. They don't do an operating agreement. The operating agreement is very important because your operating agreement overrides whatever's in statute. Otherwise, the statute will dictate how that property would pass if you have nothing else, if you've done nothing else. But if you have an operating agreement, you can put a succession plan in there and indicate what happens if you lose one partner. Do you want the spouse of that partner to come in and take ownership? Do you want a child to come in and take ownership? Or do you want the other 9 partners to be able to buy out that person's interest and then recalculate their interest for the other 9? And it depends on how much do they own of the property. Are they, do they all own a 1/10 portion of it? I don't know. I wouldn't know that until I look at the operating agreement, or I look to see what percentage each member has. And so is it manager manage? Is it member manage? There's a lot of things to untackle with that, but really it's about, for you can only handle your own portion of that. So if the operating agreement allows you to assign your portion, you can assign your portion into the trust, and then your trust can indicate how you want it to be distributed. But it depends on your operating agreement. Do they allow you to assign your portion? And so really it's your operating agreement and what you as the 10 partners have decided to do with your business. But you can indicate all of that within there, how it will pass on to the next person.
And does their individual will say there's these 10 people and this one has passed away and their will indicated that I want this part of my business to go to my kids. That's really null and void if it's not.
If the operating agreement doesn't allow
say
it.
that.
So yeah, so I wouldn't be able to assign that portion of the business if the operating agrement doesn't allow. So I would have to see what the operating agreement allows. If it allows that assignment or they get permission, they would have all of the partners would have to sign off on an assignment to say, yes, we're giving permission for this portion of the business to go to the next.
So when people come to you and they have multiple business partners, that operating agreement is very important to be able to truly identify where that portion of the business, what can and cannot be done with it.
Correct. And there's also, so some people will do buy-sell agreements where they have a plan in place to determine what happens at death, how they buy or how they sell out those portions. The other thing that people will do is they will get life insurance policies for each partner so that when a significant partner passes away, they have life insurance to cover and either buy out that person's portion, but also to cover, because maybe that person played a very important role, and so they need the additional income to be able to hire on another person to take over that role. And so life insurance plays a role sometimes in how they do the succession plan for the business. And then also, like I said, if they don't have an operating agreement, they need to create an operating agreement, and they need to start talking about what they want for that business and how they want it to play out. Because it's not just death where you lose a partner. Mm-hmm. Somebody may just want to exit that partnership. Well, what happens in that case? Same thing. Can they buy out? Can they take their 1/10 portion and give it to somebody else? What can they do with that piece of their business?
That's great information, because I know that comes up a lot. Okay, so then what is the best way then if a will does not negate going through probate? What does?
A trust.
A trust is the best thing to do.
Yes. So a trust, like I said, is very similar to a will. But a trust is not designed to go through probate. A trust is basically kind of like a contractual agreement where you indicate you're holding assets for the beneficiary or for the benefit of your beneficiaries while you're alive. And when I'm talking about a trust, there's multiple types of trusts. So when we're talking about probate avoidance, we're talking about a revocable trust. So with a revocable trust, you have a trust. So you are both the trustee. So you are the one that is going to benefit from it. You're also the trust maker. You're the one that has created the trust, and you're also the beneficiary. So right now those assets are yours and they belong to you. Okay. So you kind of hold all three of those roles when you have a revocable trust. During your lifetime, because it is revocable, you can amend it, you can revoke it, you can change it, you can update your beneficiary designations, you can update who your successor trustees are. You can make any change that you want to that document throughout your lifetime. And so one of the good things about a trust is it takes you through life. So a will only takes effect at death. During your lifetime, it does nothing for you. A trust, while you're living, you are the trustee and the trust maker. So you have access to all of that money. It's called a grantor trust, meaning you don't get a new EIN number for that trust when it's a revocable trust. It's your property. It's still in your social, you keep it in your social security number. So
And is it better to have an EIN or keep it in your own social security number?
No, you don't want to get an EIN, because if you get an EIN, now you're going to be paying taxes on an actual trust. When it's a grantor trust, everything like that, it's basically kind of like pass through. So it passes through to your individual taxes. Nothing, you don't do anything at the trust level. The only reason that you want to get an EIN for a trust is once it becomes irrevocable. So at your death, nobody can change the trust. And so it becomes irrevocable. And so the people that take over are your successor trustees. Well, that property that they're taking over and that they're going to administer, they don't own it. And so that's why it's not in their social security number. That's why you're getting an EIN, because they are in control over your assets, and they have to follow the trust and distribute your assets the way that you indicated in your trust. But they don't own those assets. They're not theirs. Like the successor trustee can't just take everything and put it into their name. It's not theirs. They don't own it. They are a fiduciary, and their role is to make sure that your trust, all the trust assets, get distributed the way that your trust document indicates. And so then they'll help you distribute those. So no, you do not want to get an EIN while you're alive. The only trusts where you get an EIN are what are called irrevocable trusts. So irrevocable trusts, once you have created those, you no longer can change them. They are non-amendable. Irrevocable trusts are usually designed if there's a significant tax issue, if you have somebody that has special needs or that is on some sort of governmental benefits. Because if somebody is on government benefits and they get a lump sum, they'll lose their benefits because they'll no longer financially qualify. So traditionally it's like a $2,000 limit is all they're allowed to have in resources. They get a lump sum of $100,000. Now they've got to spend that $100,000, and then they have to requalify for all of their benefits. And so there are specialized trusts called irrevocable trusts, like a supplemental needs or special needs trust, where you can hold money. That money can go into that trust instead of directly to that individual. Somebody else is in charge of that money. So you designate somebody to distribute that property on behalf of the person that is inheriting that money. And in that way, they don't have direct control over the money. And so because they don't have direct control, they have no ability to pull that money without the distribution trustee distributing it to them. It's not counted as a resource because they don't have control over the money. And so that's kind of how a simplified way of how an irrevocable trust works.
Okay. Now, one of the stories, one of my favorite stories that you told in our BNI was a house that went from family member to like, tell me that story on this, because it was one that as a realtor, I'm like, oh my goodness, sounds like a nightmare. I mean, nightmare for everybody involved, no matter who, what, when, where, how, or why. But that story has sat with me since you told it.
So somebody once asked me, what happens when somebody passes away and you just keep living in the house and paying the mortgage and you don't ever change it over into your name? Can't you just leave it like that? Well, this is the end result. So I have clients, a case where people passed away back in like I think it was like 1967 and then 1987. Brothers. So one parent passed away, let's say in 1967. The next parent passes away in 1987. They never changed the title of the house, so it's still in mom and dad's names. Brothers continue to live in the house for years and years and years. Now we're 2025. Parents passed away years and years ago. So what ended up happening is there's one surviving brother. There were three heirs, or three children to this parents. So each of them were entitled to inherit after. So normally after first spouse passes, it goes to survivor spouse. And then after both spouses pass, it goes to the 3 kids in equal shares. Well, now 2 of those have already passed away, so there's 1 survivor. So we ended up having to do probate on mom, dad, brother, so that the survivor brother could get title to that piece of property. So instead of just having to do 1 probate, because there was a will, but again, will, you have to probate it, and the will says it goes to my heirs. It ended up costing, it's cost them over $14,000, because there are so many, because you have to do multiple probates, and each probate costs. So all of those probates, plus we had to do an heir search to determine, did any of the children have kids? Because if any of the children have kids, that property was split into 3s, their children get to inherit before it goes to the survivor brother.
Oh my goodness.
And so it goes down this huge tree. And so we have to make sure that he's the only survivor. And in that family, none of the siblings had any children. And so it ended up going, it's still going through probate, and it's been over a year. So it's a long drawn out process, and it's a lot of money. And had they just transferred the property at, after the parents passed away, it would have made it a lot simpler, and they wouldn't be, the surviving brother wouldn't be having to deal with all of this. So
that's,
but yeah,
so
multiple probates.
like,
so I guess people don't realize, so if the parents have passed away, all of the heirs get to have a portion. And so if they've passed away, so basically you have to probate this brother and this brother until you can get to who the rightful heir is.
So everybody, now you understand. Take care of things when passing away happens.
Yes, don't there is a time to grieve, and one of the great things about an estate plan is it allows your family to grieve. And for me, that's the most important process, is allowing your family to lean on each other and to grieve and to support each other, and not having to worry about all that complicated court processes and how our asset's going to get passed, how I'm going to pay mortgage, how I'm going to do all of this, because the estate plan should cover most of that. And it should have a very streamlined process on how everything's going to get passed. The trust is probably the easiest way, because the successor trustee just comes in and takes over that property and distribute it however the trust indicates.
And if there's one piece of advice that you could give to anybody, what would be the best piece of advice that you could give to anyone?
Give your loved ones the gift of peace. Give your loved ones an estate plan. It is truly a gift, because they're going to know whether you planned or not, because they're going to be left with a mess. If you did not plan well, or you did not plan at all, they're going to end up in court. They're not going to be able to grieve and to process things. They're going to be saddled with all sorts of paperwork and a mess that they're going to have to deal with. If you have created an estate plan, you've created a very smooth, streamlined process for your family, so that, like I said, when you pass away, they can support each other. It truly is a gift, and you don't realize it until your family has to go through probate. And most people don't realize the importance of a estate plan until they've had a family member or a loved one go through probate, and they see the pain, the destroyed relationships. Because I have seen people, destroy relationships over like a $300 ring, because siblings all wanted it. And so they went to court, and they fought over it. Had the parent just told the kids who was getting the ring, it would have resolved all of that conflict. And you see tons of broken relationships because of fights through probate. A probate is similar to a divorce. Tons of fighting, tons of emotion, tons of grief. And so it's just a messy situation all around.
Awesome. Well, I think one of the things that it can be as minimal as a $300 ring. And it's crazy how much death just changes people, and it's no longer becomes friendly sometimes. So it doesn't matter how small you might think it is, account for everything.
Yes. And so one of the most important things is having a plan for all of your sentimental items, making sure that finding out from your kids ahead of time, what is sentimental to them? What is it they want? What is it that they're going to fight over, so that you can resolve that while you're still alive? And sometimes my clients will just give the property to them while they're still alive, so they get to see their enjoyment with that piece of property while they're still alive. But otherwise, making sure that you've indicated who gets each piece of sentimental property, so that there's no fighting
And is
And
that
yeah.
all included in everything that
Yeah.
you
So,
do?
so
Okay.
anytime you do a will or a trust, you'll get a personal property memorandum, and that's where you write any of your tangible property, things that you can touch.
Okay.
You indicate who gets that piece of property, and then you describe the type of property that you want them to go to. If you're married, you can indicate whether you want that piece of property to go after first spouse passes or after both spouses
Oh,
have
okay.
passed or both parents have passed.
Okay.
But yes, that's another
Perfect.
wonderful document.
Well, I want to say thank you for all of this tremendous, wonderful information. And again, if you have any questions, Sarah at Murillo Law, amazing. She's here in Goodyear, Arizona, and we will put all of her information in the video down below, whatever.
Thank you very much. I
Thank
appreciate you
you.
taking the time to talk to me today.
Absolutely. I appreciate it.